Hi all, this video lecture kind of focuses in on the Fourth Amendment of the Constitution. So the text of the Fourth Amendment is that the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. So that's kind of the focus of the Fourth Amendment. Really important word here is unreasonable searches and seizures. That really focuses in on the fact that some searches are going to be inherently reasonable. Also, this requirement for probable cause is important because that is going to be the standard for searches, regardless of what's going up, regardless of whether they have a warrant, officers have a warrant or not. So the premise of the Fourth Amendment is that there should be limited government power, and that's important for everybody. The balance is required for democracy. A search is an examination of a person, place, or vehicle for contraband or evidence of a crime, and a seizure is a taking by the law enforcement or government agent of contraband evidence of a crime or a person into custody. Okay. The Fourth Amendment is really important for law enforcement, for criminal justice and law enforcement. It really defines and limits when and how police officers can conduct those searches and seizures. So it's an important part of it's a very important part of criminal procedure. And again, the slides here highlight the same thing, that only unreasonable interference is prohibited under the Fourth Amendment. So going back through some really important cases, one is Wolf versus Colorado in 1949. The question was, are states required to exclude illegally seized evidence from the trial under the Fourth and 14th Amendments? And the holding was yes, that government agents, state, federal, local, are all regulated by the Fourth Amendment. Private individuals or government agencies are not regulated by the Fourth Amendment. So, for instance, loss prevention, who are employed by Walmart or Target, are not required to follow the Fourth Amendment. It's really the police officer, the government agents. UPS employees can open packages and inspect their contents. Airline employees can. An airline employee, though, who is acting according to FAA regulations, is acting in the government capacity and is governed. So that's kind of who is acting and why they're acting kind of help us determine who's a government agent. But that's the starting point. Question 1. Is there a government agent, yes or no? If the answer is no, the Fourth Amendment doesn't apply. Going back, we kind of looked at the text of the Fourth Amendment a couple minutes ago. When we analyze this, we break it down into two clauses. The reasonableness clause, which is that first part, that we have the right to be secure against unreasonable searches and seizures. And then there's the warrant clause that requires probable cause, oath and affirmation, particularly describing the place to be searched and the persons or things to be seized. There have been two separate interpretations of the Fourth Amendment, but since the 1960s, the court has really focused on the reasonableness requirement of the Fourth Amendment. Warrantless searches and seizures are valid and constitutional when they're reasonable, when they're sensible. So what is reasonable? Reasonable is this kind of sensible, rational, justifiable use of government authority to search or seize. Reasonableness is determined by the case-by-case methods. We do not have this bright line approach. We don't have one. What we have instead is this totality of the circumstances. Courts, judges look at considering everything the officers knew. Was it reasonable here? If it is, then the Fourth Amendment doesn't prohibit it. Searches and seizures require probable cause, which exists when facts and circumstances within the officer's knowledge of which they had reasonable, trustworthy information are sufficient in themselves to warrant a person of reasonable caution in the belief that an offense has been or is being committed. So officers need to be able to explain those facts and circumstances, and they need to be able to explain why the information is valid or trustworthy. The totality of the circumstances is examining everything and then determining, is this reasonable, kind of in hindsight. It's really important to distinguish here between probable cause and reasonable suspicion. Probable cause is a stronger standard than reasonable suspicion. Probable cause requires more. It really requires the officer to be able to explain those facts and circumstances, explain their sources, and that a reasonable officer would agree with them. Probable cause needs to exist before the search or seizure. And then reasonable suspicion would be more casual. It's reserved for stops and frisks, and it's a little bit more than a hunch, but it's less than probable cause. Probable cause needs to exist before the search or arrest can occur. Facts and evidence obtained after the search and arrest cannot be used to establish probable cause. They can strengthen the case that probable cause did exist. For instance, an odor of alcohol, when a driver rolls down their window, but can strengthen that the officer made the correct call here. The officer still needs to be able to say, I observed the car swerving, I observed this, and in my training and experience, that is the hallmark of a drunk driver. Okay. When we have a warrant, officers need to establish that the source is credible and that they've tested the informant's reliability of the information, and that they are not relying on invalid or unfair sources. Because remember, we require the officer to explain the facts and circumstances, and a reasonable officer would also need to feel that the information is acceptable. So it kind of builds into the requirement here for when law enforcement can use informants. In Illinois versus Gates, we see the police receive an anonymous letter outlining details about the defendants being involved in drug trafficking. And the question was there probable cause? And the Supreme Court said yes, that letter was probable cause. Given the totality of the circumstances, the amount of information in the letter, that was a reasonable police officer was justified in relying in that letter. Police officers, government agents who have probable cause need to go before a magistrate or judge and swear under oath about the information. And then the judge is the one that determines if probable cause exists under the totality of the circumstances. Would a reasonable person believe what the officers claim? An officer might be told to come back later with additional information. A judge might refuse to sign the warrant. And then today, judges will grant telephone warrants. So the police officers can call judges on weekends or nights to get that warrant. If the officer receives a warrant, there's a knock and announce rule. They need to knock and announce their presence before entering into a dwelling. I don't like this breaking. For entering in a dwelling to execute the warrant. This is intended to prevent the occupant from resorting to violence or fear, thinking that someone's breaking into their home. when really it's a legitimate use of government authority. In United States versus Banks, we kind of were dealing with a question of, is 15 to 20 seconds long enough for officers to wait after knocking and announcing before entering the residence? And the court said yes. That was a warrant to search for drugs, and the Supreme Court said, yeah, someone could flush drugs in 15 to 20 seconds or dump it on the sink or garbage disposal. So waiting the 15 to 20 seconds was acceptable. This continuum of context is really dealing with how police can gather information, how they can support their efforts to get warrants. I would like to shift forward, though, a little bit in our last few minutes here of this lecture to talk about stop and frisk, because that's a really important topic. It is governed by the Fourth Amendment. Stops are brief detentions of a person based on specific and articulable facts for the purpose of investigating suspicious activity. Articulable facts need to be described in clear, distinct statements, and if suspicion exists, then a frisk can occur, which is a reasonable, limited government pat-down, a limited pat-down for weapons for the protection of the officer. This comes to us from Terry v. Ohio in 1968, where Terry and two other men were observed by a plainclothes officer doing what the officer believed to be was casing a jewelry store. The officer stopped them and frisked them because of the behaviors, and he found weapons on two of them. And they challenged that, saying that their Fourth Amendment rights were violated. But the Supreme Court found that the officer was able to articulate facts that were beyond a hunch, and that a reasonably prudent officer would have been reasonable in assuming that Terry was armed and that there was a threat to the officer's safety. So that's stop and frisk is very limited, and it requires a lesser standard than probable cause. Lesser standard, okay? The last few slides here are looking at what happens when someone's Fourth Amendment rights are violated. An unlawful search or seizure can result in the evidence being excluded from court, and the officer could receive internal sanctions, as well as liability. The exclusion of the evidence is called the exclusionary rule. This is a judge-made rule designed to prevent police misconduct. Evidence seized in violation of a constitutional right, this person's constitutional rights, cannot be used against them. This is the most frequently used way to address constitutional violations, and this applies to states and federal government as of 1961 in the Mapp v. Ohio case. Dalry Mapp was at home. Officers pretended they had a warrant, came in, found some pornographic magazines, and charged her with them, and the court found that wasn't reasonable. They didn't have a warrant, they didn't have probable cause, and because they violated her rights, they could not use the evidence they obtained to prosecute her, to convict her of a crime. The exclusionary rule also helps judges kind of protect constitutional rights, to preserve judicial integrity by giving teeth to the Fourth Amendment. Additionally, searches that kind of shock the conscience also violate due process, and evidence obtained is inadmissible. There are a couple of exceptions to the exclusionary rule. If officers are acting in good faith, like they have a search warrant, then it's acceptable. If there's a harmless error, officers have a valid independent source of that information, or if they would have discovered it anyways, then the exclusionary rule does not apply. That's where we're going to go ahead and stop here. Then we're going to have a little bit more time on the Fourth Amendment, so you'll have another video lecture coming your way soon. Let me know if you have any questions or concerns about the Fourth Amendment. I look forward to speaking with you.